welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Supreme Court has held that capital punishment is an exception. Even in cases of multiple murders, death sentence should be avoided if there is a possibility of reform. In the Malankara-Jacobite dispute, the top court has set aside the High Court's direction to hand over churches and remitted the matter back to the Kerala High Court. NBDSA has directed News 18 Rajasthan to take down the broadcast where its guest panelist linked Tirupati Laddu adulteration to Congress party. The Delhi High Court has held that foreign nationals coming to India are not required to declare personal gold jewellery to customs. Saying that tanneries have caused irreversible damage, the Supreme Court has passed directions on pollution in Tamil Nadu's Vellore, asking polluters to compensate. The Calcutta High Court has constituted an SIT to probe Sandeshkhali gang rape case and also flagged delay in investigation. The Bombay High Court has issued interim order prohibiting sale and immersion of POP idols for Ganesh Maghi festival. And the Supreme Court is set to decide whether property of a person accused under Prevention of Corruption Act can be seized or frozen under Section 102 of CRPC or not. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit our website at www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. The Supreme Court has upheld a man's conviction for murdering his wife and 4 daughters but reduced his death sentence to life imprisonment without remission. The court considered his record of no past crimes, positive prison reports and past rulings against the death penalty in similar cases. A bench of Justices Vikram Nath, Sanjay Karol and Sandeep Mehta heard the case in which the appellant was convicted of murdering his wife and 4 minor daughters based on circumstantial evidence and was sentenced to death, a verdict which was later upheld by the High Court. The appellant had challenged imposition of death penalty, contending that the offence does not fall within the rarest of the rare category, calling for death penalty. The top court agreed that the case does not fall within the rarest of the rare doctrine propounded in the case of Bachchan Singh versus State of Punjab in 1980. Let me tell you here what was observed in this Bachchan Singh case, as the court has reiterated in this case also. The death sentence is to be imposed only in exceptionally grave circumstances, such as, first, when the crime is extremely brutal, grotesque, diabolical or revolting, shocking the collective conscience of the society. Second, when the crime demonstrates extreme depravity or inhumanity, such as mass murders, heinous sexual offences followed by murder or killing of law enforcement officers. And third, when there is no possibility of the convict being reformed and sentencing them to life imprisonment would be inadequate in serving justice. The bench has observed that before determining whether a case falls under rarest of the rare category, factors such as motive, manner of execution, severity of the crime, and convict's potential for rehabilitation must be considered. It said that if reform is possible, then life imprisonment should be imposed instead of death penalty. The court added that even in cases involving multiple murders, no death sentence could be imposed if the convicts display a reform potential supported by other mitigating factors such as age, lack of criminal antecedents, income, etc. So in this case, the court has partly allowed the appeal while maintaining the conviction but modifying the sentence from death penalty to life imprisonment without remission. You can visit livelaw.in to read in detail. And now an update from the Supreme Court in the Malankara-Jacobite dispute. The bench of Justices Suryakant and N. Koteshwar Singh today set aside the Kerala High Court's order that had directed the state authorities to take possession of 6 churches from the Jacobite faction and hand them over to the Malankara Orthodox faction. To give you a brief background here, the dispute between Jacobite Syrian Church and Malankara Orthodox Syrian Church is about who has the right to control and manage certain churches in Kerala. This conflict goes back over a century and is mainly about differences in religious practices, leadership, and interpretation of church laws. Both factions were once part of the same church but split due to disagreements over authority. The Supreme Court ruled in the year 2017 that Malankara Orthodox Syrian Church, governed by the 1934 Constitution, has the legal right to control these churches. However, the Jacobite faction has resisted handing over, leading to legal battles. The matter reached the top court again last year when the petitions were filed by the Kerala government, Kerala police, and the Jacobite church members challenging challenging a Kerala High Court order from October. Now, this High Court order had directed district authorities to take control of the 6 churches after complaints of the Jacobite faction obstructing the same. Today, the Supreme Court asked the High Court to reconsider contempt petitions in light of several issues raised in today's order. The court expressed concerns over the police being involved in religious disputes and emphasized the need for the High Court to examine key questions such as true meaning of previous Supreme Court judgments and whether those judgments had been fully implemented. The court also raised questions about the impact of Kerala Right of Burial of Corpse in Christian Cemeteries Act 2020 on the contempt petitions and whether the civil administration should be involved in taking over religious places. While the Supreme Court did not make any conclusions on the merits of the case, it has remitted the matter back to Kerala High Court to decide the fate of contempt petitions afresh after hearing all parties. During the hearing today, senior advocate K.K. Venugopal, representing the Malankara side, requested that this order be kept in abeyance, arguing that it would reopen settled disputes. However, the bench said it preferred to have the High Court's view on the issues and hoped that it would find a way to address concerns without police involvement in religious matters. Also, the state of Kerala had today submitted data on the population of both communities and the disputed churches, as was asked by the court at the last hearing. But today, the court decided it was not necessary for disposal of the case. In the next update, the News Broadcasting and Digital Standards Authority, that is NBDSA, has directed TV news channel News 18 Rajasthan to remove within 7 days from all its platforms the broadcast footage where a guest panelist had linked the alleged adulteration of Tirupati Laddu to the Congress party. In its order, NBDSA noted that overall tone of the broadcast seemed to be less about seeking accountability for adulteration. Instead, it provided the panelist, Swami Dipankar, with a platform to air his views which deviated from the intended subject for the interview. The order was passed on a complaint against the broadcast aired by the channel on 21st September 2024. The complainant had questioned the broadcaster as to why it was spreading fake news that animal fat in Tirupati Balaji Temple Prasadam Laddu is a Congress party conspiracy. He claimed that this was against accuracy, objectivity, neutrality, and fairness. After reviewing the broadcast, NBDSA in its order noted a discrepancy and observed that the anchor could be seen questioning the interviewee as to whether adulteration in the Prasad Laddu was a conspiracy against the Hindus. The authority has advised the broadcaster to bear in mind specific guidelines for anchor conducting programs, including debates, while inviting any person as an interviewee in its broadcast. It has asked the broadcaster to adhere to the specific guidelines covering reportage, under which facts should be clearly distinguishable from and not be mixed up with opinion, analysis, and comment while reporting or discussing any subject. It also found that contrary to the broadcaster's submission that it had removed the interview from its portal, the broadcast appeared to be still available on the broadcaster's YouTube channel. Thus, it has been asked to remove the video from all platforms now. Moving further, the Delhi High Court has ruled that foreign nationals visiting India are not required to declare their gold jewellery when entering the country if it is for bona fide personal use. The court emphasized that the Customs Department must distinguish between jewellery and personal jewellery when enforcing the baggage rules of 2016 under the Customs Act. In this case, a foreign national from Thailand was travelling to India to visit her family and had her gold bangles seized by the Customs Department upon arrival. The Customs Department argued that all jewellery carried by foreign tourists must be declared, while the petitioner argued that according to previous rulings of the courts, personal jewellery is exempt from such requirements. The High Court agreed with her, stating that the gold bangles were part of her personal belongings and there was no need to declare them. The court also noted that jewellery should not be excluded from the category of personal effects, which are typically exempt from duty under baggage rules. The court cited earlier judgments, including a judgment from Supreme Court in 2017, which recognized that jewellery could be considered part of a tourist's personal effects. The court also observed that in this case, gold bangles had been detained for almost a year without any formal notice. The High Court has now directed the Central Board of Indirect Taxes to reconsider the baggage rules and issued some directions also, like detention receipts should include the tourist's contact details, including email and phone number. Colored images of detained jewelry must be attached to the receipt, and that a copy of the image should be provided to the tourist and retained by the Customs Department. The Apex Court has today issued key directions to tackle pollution in Tamil Nadu's Pallar River caused by discharge of untreated effluents from Tanneries in the Vellore district. A bench of Justices J.B. Pardiwala and R. Madhavan has ordered compensation for affected families, recovery of costs from polluting industries under the polluter pays principle, and formation of an expert panel to assess and mitigate ecological damage. Justice Mahadevan, reading the operative part of the judgment, highlighted that unchecked discharge of effluents has led to irreversible environmental damage, harming water bodies, agriculture, and public health. The court said that the order is in the nature of continuing mandamus, meaning that it will actively monitor the implementation. A compliance report is expected within 4 months. Some of the directions issued include that polluting industries must compensate victims and bear the cost of damages until the harm is reversed. The state must implement a comprehensive plan to restore the Pallar River by removing pollutants and ensuring adequate water flow. Regular inspections of tanneries will be conducted to ensure compliance with reports made public. And pollution control boards must set emission standards in line with international norms, and citizens will have platforms to report pollution incidents, and strict action including license cancellations will be taken against violators. Calling the judgment path-breaking, Justice Pardiwala warned that non-compliance could result in strict action and those responsible for breach would be sent to jail. And now let me tell you, the Calcutta High Court has constituted a special investigation team to probe allegations of gang rape in West Bengal's Sandeshkhali, allegedly involving political influential persons. Justice Tirthankar Ghosh formed the SIT comprising of IPS Rahul Mehta, SDPO of Baduria Birsat Police Station, along with Bireshwar Chatterjee, the Assistant Commissioner of Police Homicide Section, Lal Bazar. While producing the case diary earlier this week, the court had expressed its dissatisfaction with the probe. Noting that already there had been a delay in the case, the court directed that the records of the case be transferred to the SIT and a progress report be submitted by it in a month. In another update, the Bombay High Court has today issued an interim order against manufacture, sale and immersion of idols made of plaster of Paris for the upcoming Ganesh Maghi festival. A division bench of Chief Justice Alok Arade and Justice Bharati Dangre took note of the Central Pollution Control Board's guidelines on idol immersion issued on 12th May 2020, banning the use of POP idols. The Petitioners' Council submitted that despite the guidelines and High Court's previous orders prohibiting POP idols usage, they are being sold and distributed by vendors. The Respondent Association of Idol Makers submitted that banning POP idols would affect their profession. They argued that the guidelines are not binding and that the Pollution Control Board did not carry out any environmental assessment before issuing them. However, the High Court observed that it had in June 2022 dismissed the challenge to the ban of POP Ganesh idols in the case of Ajay Vishampayan versus State. The court also referred to a 2023 Madras High Court's decision where it was observed that artisans had no right to make the idols using POP material. The said decision had been also upheld by the Supreme Court. Therefore, the High Court passed an interim order today prohibiting the sale and immersion of POP idols by artisans and vendors. The court will now hear the matter on 20th March. The Supreme Court is set to decide the issue as to whether Section 102 CRPC, which deals with police officers' power to seize certain property, shall apply to a criminal case registered under Prevention of Corruption Act or not. This is because there are divergent High Court views on this point. The case here pertains to a person accused under provisions of Prevention of Corruption Act whose assets, including fixed deposit accounts, were frozen by authorities by invoking Section 102 of CRPC. Aggrieved by the same, the accused challenged the freezing of bank accounts before the Calcutta High Court, where the authorities took a stand that the bank accounts had only been seized and not attached, and as such, Section 18A of PC Act was not applicable. For your understanding, Section 18A of the Prevention of Corruption Act governs the attachment, administration, and confiscation of property and money obtained through corruption. As the respondents' bank accounts were frozen by invoking Section 102 of CRPC, the High Court had set aside the impugned order and directed directed defreezing of the said accounts. Against this order, the state of West Bengal has approached the Supreme Court. The matter was before the bench of Justices Sanjay Karol and P.K. Mishra, which noted that this was an interesting issue. Let me also tell you, diverse views have been taken by the High Courts of Madras and Patna with regard to applicability of Section 102 CRPC in seizure and freezing of bank accounts in a criminal case registered under the PC Act. While the Madras High Court has held in favor of such application, the Patna High Court has held that such seizure and freezing can be made only under Section 18A of the PC Act. Well, now the Supreme Court is set to decide the issue, and meanwhile it has stayed the operation of the High Court order which set aside freezing of bank accounts. Stay tuned.